Hello friends, welcome to the first session on Indian Partnership Act of 1932. What does this act talk about? It talks about the law of partnership. This act came into force on 1st October 1932. Let us start this session with concept of partnership. As per section 4 of the act, partnership is the relation between persons who have agreed to share the profits of business carried on by all or any one of them acting for all. The persons who enter into such relationship are individually called as partners and collectively as firm, and the name under which their business is carried on is called by the firm name. So who can be a partner? Let us take a look. Person. Do you remember what we had studied in the Indian Contract Act? According to section 11 of the Indian Contract Act, every person who is of age of majority according to the law to which he is subject to, and who is of sound mind and is not disqualified from contracting by any law to which he is subject, is competent to become a partner. The term person does not include a partnership firm or a limited company. For instance, a firm ABC cannot form a partnership with firm BCD. But all the partners of firm ABC and all partners of the firm BCD can form single partnership subject to the rules regarding the number of partners. Minor. A minor cannot be a partner. Section 31 lays down that a person who is a minor according to the law to which he is subject may not be a partner in a firm, but with consent of all the partners for the time being, he may be admitted to the benefits of partnership. Lunatic. A person who is of unsound mind cannot become a partner. Alien enemy. An alien enemy cannot enter into a contract of partnership, though an alien friend can do so. Company. A corporation being an artificial person can neither become a partner nor can it enter into a partnership agreement. Woman. A woman, married or unmarried, can be a partner. Insolvency. When the partner of a firm is adjudicated as insolvent, he ceases to be a partner from the date on which the order of the adjudicated was passed by the court. Alright, now let us see what the essentials of a partnership are. There are 5 essential elements which are required under section 4 of the Act for constituting a valid partnership. First, partnership is an association of 2 or more persons. Friends, there must be a contract between 2 or more persons. Unless there are at least 2 persons, there cannot be a partnership. One person cannot be a partner with himself. It goes without saying that when for an existing partnership firm, the number of partners is reduced to 1, the firm is compulsorily dissolved. Also, the maximum number of partners in a partnership firm as per section 11 of the Companies Act 1956 puts a limit at 10 in case of banking business and 20 in case of any other business. Second, partnership must be the result of an agreement between 2 or more persons. There must be an agreement between the partners to form the partnership. That is, all the partners must enter into an agreement to constitute a partnership firm. The agreement may either be express or implied and may be for a fixed period or for an uncertain period. Now, since we have already studied express and implied in Indian Contract Act, I am sure you all are able to relate to it better. Third, the agreement must be to carry on some business. The existence of a lawful business is essential to form a partnership. The idea behind the business must be to secure some gain. A society formed for the charitable or religious purpose is not a partnership. To constitute partnership, there must be a business in existence. An agreement to carry on business at a future time does not result in a partnership. That is, the evidence of partnership is business, which is in actual existence. It should not be something which will be in the distant future. Fourth, the agreement must be to share profits of the business. Sharing the profits of a business is not only the evidence but conclusive evidence of partnership. The partnership must aim at making profit, because then only the profit may be divided amongst the partners. It basically means that where only one partner is entitled to the whole profits, there can be no partnership. Fifth, business must be carried on by all or any one of them acting for all. The law of partnership is an extension of the law of principal and agent. The definition of a partnership says that the business must be carried on by all the partners or any of them. That is, there must be a mutual agency. Thus, every partner is both an agent and principal for himself and other partners. Okay, now that we have seen who can be a partner and some essentials of a partnership, let us study some definitions as per the Indian Partnership Act of 1932. An act of a firm as per section 2A. This means any act or omission by any or all partners of the firm which gives rise to a right enforceable by or against the firm. Business as per section 2B. This includes every trade, occupation and profession. Prescribed as per section 2C. This means prescribed by rules made under this act. Third party as per section 2D. This means any person who is not a partner in the firm. Expressions defined in Indian Contract Act as per section 2A. All the expressions defined in the Indian Contract Act 1872 but not defined in the Indian Partnership Act 1932 have the same meaning in Partnership Act as have been assigned by the Indian Contract Act 1872. Firm. Persons who have entered into partnership with one another are called collectively a firm. A firm is not a separate legal entity distinct from its members. It is merely a collective name of the individuals composing it. As a matter of fact, the assets of the firm are the joint property of the partners. Legal position of a firm is that it has no independent existence apart from its members. A firm as such is not an entity in law and is not a person within the meaning of section 4 of Indian Partnership Act 1932. A partnership firm cannot be distinguished from its partners. The rights, duties and obligations of a firm are actually the rights, duties and obligations of the persons who own the firm. The legal position of a firm is that it cannot possess property and therefore it cannot be a debtor or a creditor. Firm name. The name under which the partners carry in their business is called the firm name. The partners of a firm may carry on business under any name and style which they please to adopt. The name adopted should not be such that it will mislead the public into confusing them with a firm of repute already in existence. Further, section 58(3) puts some constraints on the firm name. A firm name shall not contain any of the words, namely crown, emperor, empire, imperial, king, queen, royal, or words expressing or implying the sanction, approval or patronage of government or the crown representative. It can only be used when the state government signifies its consent to the use of such words as part of the firm name by order in writing. Let us now move ahead to distinction between partnership and a company. Registration. Registration of the firm is not compulsory under the Partnership Act. However, registration of a company is compulsory under the Companies Act. Legal status. A partnership firm has no existence apart from its members, whereas a company has a separate legal existence of its own and is considered a separate entity from its members. Membership. Minimum number of persons is 2 and maximum is limited to 10 in case of banking business and 20 in case of general business for a partnership. whereas in case of public company, minimum members required are 7 and maximum is unlimited. In case of a private company, minimum is 2 and maximum is 50. Liability. Every partner has an unlimited liability and is also personally liable for all the debts of the firm, whereas in a company, liability of the shareholder is limited to the extent of the unpaid amount of the shares. Management. A partnership firm is managed by the partners themselves, whereas in case of a company, board of directors who are elected from among the members of the company are only entitled to conduct the business of the company. Duration. Partnership has no perpetual existence. It is dissolved on the death or insolvency of any one partner, whereas company has perpetual existence. It is not dissolved on the death or insolvency of any shareholder. Profit. Partners get a share of profit out of the profits of the firm, whereas in a company, shareholders of the company get dividend on the shares held by them. Transfer of interest. A partner cannot transfer his interest without the consent of all other partners, whereas shares are freely transferable in case of a company. Law of agency. Every partner is an agent of the firm and the firm is also an agent of each of its partners, whereas in case of a company, neither the company is an agent of its members nor are any members the agent of the company. Contractual capacity. Partners can contract with other partners but not with the firm as a whole, whereas the shareholders of a company can enter into contracts with the company. Property. Property of the firm is the property of the partners, joint owners, whereas property belongs to the company and shareholders are not the joint owners. Audit. The audit of the accounts of the firm is not compulsory, whereas in case of a company, accounts of the company must be audited by an auditor. Creditors. Creditors of the firm are also the creditors of the partners individually, whereas creditors are only the creditors of the company and not of individual shareholders in case of a company. Formation. A partnership is governed by the Partnership Act and the formation of the firm is easy, whereas a company is governed by the Companies Act and has to observe a number of legal formalities for its formations. And lastly, dissolution. A firm may be dissolved at any time by any partners, whereas in case of a company, it comes to an end only when it is wound up according to the provisions of Companies Act. Friends, I hope you are finding this session interesting. Let us now see the difference between the partnership and the joint Hindu family. In Hindu law, a business is as inheritable as any other property. A Hindu joint family which carries on a trade inherited from its ancestors is called Hindu joint family firm. A person becomes entitled to a share in the family business by birth or adoption. He becomes the joint owner of the business and not a partner. Such joint ownership is created by law and is governed by the Hindu law. Here is the difference. Creation. Partnership is created by an agreement, whereas joint Hindu family firm is created by status. Law. A partnership is governed by the Partnership Act, whereas a joint Hindu family firm is governed by Hindu law. Registration. The partnership firm is usually registered, whereas there is no concept of registration in case of a joint Hindu family firm. Number of members. The number of partners should not exceed 10 in case of banking business and 20 in case of any other business, whereas in case of a joint Hindu family firm, there is no limit to the maximum number of members. Admission. A new partner can be admitted only with the consent of all the existing partners, whereas in case of a joint Hindu family firm, a person becomes a member only by birth in the family. Female members. A partner may be a male or female, whereas only the males can be the members of the joint Hindu family firm. Minor members. Under section 30, a minor though cannot be a partner, can be taken in a firm for profits only. However, for a joint Hindu family firm, every child of the family is its member since birth. Law of agency. Law of agency applies to a firm as all the partners are the agents of the firm, while the firm is the agent of all the partners. Whereas, in case of joint Hindu family firm, the law of agency does not apply, as the members are not the agents of the family, only the Karta is liable to all. Liability. Every partner is liable to unlimited extent for debts of the firm. Whereas, in case of joint Hindu family firm, only the Karta has unlimited liabilities. Other members or co-partners are liable to the extent of their share in this. Death. Death of a partner dissolves the firm unless otherwise agreed by the partners, whereas the death of a member of the joint family has no effect on the firm. The firm continues with other members. Right to demand accounts. A partner has the right to demand and inspect the accounts of the firm, whereas a member has no right to demand the accounts of the past dealings of the family in case of the joint Hindu family firm. And lastly, authority. Partners have authority to borrow and bind other partners, whereas in case of a joint Hindu family firm, only Karta of the joint Hindu family firm has an authority to borrow and bind other members. Now comes partnership and co-ownership. The term co-ownership or joint ownership means that number of persons are having the same ownership of some property jointly. Example, if Mr. A and Mr. B jointly purchase a house, then they are co-owners but not necessarily partners. Here is the comparison between the two. Creation. Partnership is created by an agreement, whereas co-ownership may be created whether by status or by agreement. Transfer of interest. A partner cannot transfer his interest without the consent of all other partners, whereas co-owner may transfer his interest in co-ownership without the consent of the other co-owners. Registration. The partnership firm is usually registered, whereas there is no concept of registration in case of co-ownership. Number of members. The number of partners should not exceed 10 in case of banking business and 20 in case of any other business, whereas in co-ownership there is no such limit on the number of co-owners. Business. To carry on business is an essential element of partnership, whereas co-ownerships may exist without carrying on any business. Object. The primary object of partnership is to earn profits. In co-ownership, it is not necessary to earn profits. Profits. An agreement to share profits is an essential element of partnership. The co-ownership may have interest without doing any business, and sharing profits does not arise. Law of agency. Partners are agents of one another, whereas one co-owner is not the agent of the other in case of co-ownership. Lien. A partner has a lien on the property of the firm owned in common, whereas co-owner has no lien on the property owned in common. Right of partition. Right of partition is not possible in case of partnership, whereas in case of co-ownership, a co-owner may ask for the partition of the property under co-ownership. Lastly, partnership and club. A club is an association of a peculiar nature. The objective of such an organization is not the acquisition of profits, but the promotion of some beneficial or social objects, such as promotion of health or providing creation for its members. It therefore differs from partnership on some points. Let us see which. Number of membership. The number of partners should not exceed 10 in case of banking business and 20 in case of any other business, whereas there is no limit on the number of membership for a club. Business. The main object of partnership firm is to carry on business, whereas the club has no object to carry on business. Liability. All the members are severally and jointly liable for the debts of the firm. The members have no such liability for the debts of the club. Profit. Partnership is formed to share the profit among the partners. The club is not formed with the object to earn profit and share it among its members. Management. All the partners are entitled to participate in the management of partnership business. The management of a club or an association is usually vested in an executive body. And lastly, law. Partnership is governed by Indian Partnership Act and Indian Contract Act. Club or a society is governed by its bylaws and by the Societies Registration Act 1860. Now let us move ahead to the test of partnership. Friends, the question whether a particular group of persons constitutes a partnership or not is often a difficult one to decide. A partnership is a relation between persons who have agreed to share the profits of a business carried on by all or any of them acting for all. If there is a specific agreement of partnership between the partners, then there is no difficulty in knowing whether the group is partnership or not. An association of two or more persons entering into an agreement to share the profits may not necessarily determine partnership, because such an agreement may not carry on business and be formed for charitable or social objects. Similarly, the business may be carried on for profits, but the agreement does not provide for sharing profits, then there cannot be a partnership. It should be noted that the sharing of profit is not a conclusive proof of the real relation of partnership. It is a prima facie evidence of partnership. The real relation between the partners is that of mutual agency. Section 6 specifies some cases where there is no real relation of partnership between the group of persons. Joint owners sharing profits. The joint owners of a property who share the profits or gross returns arising from the property are not partners. Example, X and Y are joint owners of a shop which they let out at Rs 5,000 per month, sharing equally by them. Money lender sharing profits. You all know, money lender is a person who lends money on interest. Sometimes, a money lender receives, in addition to or in place of his interest, a portion of the profits of a business. The money lender is not a partner of the firm. Example, X advanced some money to Y and Z, two merchants. The merchants agreed to carry on the business subject to the control of X in several respects. X thought that he would receive a commission of 20% on all profits. However, later it was held that there was no partnership between X and the merchants. The object of the agreement was to give X the maximum security for the repayment of his loan. Servant or agent receiving share of profits. A servant or an agent who receives a share of profits as a part of his remuneration is not a partner. Example, X, a contractor, undertook a contract of loading and unloading railway wagons. He appointed Y as his servant to manage the work. It was agreed that the servant would receive 75% of the profits as his remuneration and would bear all the losses, if any. It was held that Y was the agent of X and not his partner. Widow or child of a deceased partner. A widow or child of a deceased partner receiving a share of profits as annuity is not a partner of the firm. Example, X, Y and Z were carrying on a business of garments in a partnership. X passed away. After X's death, Y and Z continued the business. It was agreed to give 10% of the profits of the firm to W, the widow of X, every year. In this case, W is not a partner in the firm. Seller of goodwill. If a previous owner of the business shares profit of the firm as consideration for the sale of the goodwill of the business, such a person is not a partner of the firm. In all the cases we discussed just now, the element of agency necessary to constitute partnership is absent. A creditor or the widow and children of the deceased partners cannot bind the firm by any act done on behalf of the firm. Similarly, where two persons who jointly own a house let out the same to a tenant and divide the rent amongst themselves, they are only co-owners but not partners with respect to the house or rent, because the idea of representation of one person by the other is absent. Thus, the true test of partnership is agency and not sharing of profits. Example, in one of the cases that took place in our country, the defendant was admitted as a partner by the plaintiff for 1 year, subject to the terms that the defendant would get rupees 500 in lieu of profits but would not be responsible for the losses. No capital to be contributed by him, and he would have all the rights of a partner. It was held that the defendant was a partner. Friends, we have thus completed first session on the Indian Partnership Act 1932. Let us quickly take a recap of what we covered today. We have covered who is eligible to become a partner, some definitions as per the Act, and some essentials of a partnership. Then we saw the difference between partnership and company, partnership and a Hindu joint family, partnership and co-ownership, and partnership and a club. We have also studied the test of partnership. I hope you have enjoyed learning about the Indian Partnership Act. Have a good day ahead.